Hi there. I'm Dr. Suzanne Bechtel, a passionate legal educator dedicated to making legal studies clear, practical, and even a little inspiring. On this channel, you'll find a growing collection of videos designed to help you prepare for the Certified Paralegal exam. It covers key topics, breaking down complex concepts, and offering study tips that actually stick. If you're looking for a deeper dive, check out my Teachable School, where I offer structured courses, interactive tools, and exclusive resources to support your journey towards certification. Watch this video to the end and you'll find a coupon code for a discount. Don't forget to subscribe and explore the playlists. Your success on the NALA CP exam starts here. Now, before we move on to the lecture, there are two important disclaimers. First of all, this is not considered legal advice. Everything shared here is designed to support your learning journey. Also, I am not a lawyer. This course is designed to help you understand the concepts of the exam. Thank you.
Hello, this is Dr. Suzanne Bechtel, and this is the first of 3 lectures on contracts, offer, and acceptance. So we're going to explore the essential principles that govern contract offers and outlining the legal requirements in this particular one for forming valid contracts and the role of offers. We'll cover the distinction between proposals and offers and valid offer requirements, the objective test, definiteness of terms, output and requirements contracts, and communication essentials. The differences between proposals and offers will be covered next, and preliminary negotiations and their role in formation of a contract. So we need to first of all delineate the difference between proposals and offers. A proposal is a preliminary plan or a suggestion to make a start or to start discussions or negotiations. Definition of offer is defined as an offer as a definite promise or commitment to enter into a contract under specified terms. The key differences between the proposal and the offer is proposals invite negotiations, while offers indicate an intent to be legally bound upon acceptance. And so we have to ask ourselves the question, whether preliminary negotiations and how they play a role in formation. We cover the testing the waters concept. Preliminary negotiations often involve offerors exploring interest before making formal offers. A preliminary negotiation as a proposal, it can be considered a proposal that may lead to a binding contract if it's accepted. The lack of offer intent without a clear intention, cannot be recognized as a valid offer under contract law. So the offer cannot lack intent. And intent is a valid legal criteria. It is a fundamental requirement for any proposal to be legally considered a valid offer. So intent must be present for it to be a legally valid offer. It sounds simple until you're trying to solve these problems. So requirements for a valid offer, we're going to talk now about communication of intent, the objective intent, and the reasonable person test. Look to areas of precision, definiteness, and specificity in offers. So an offeror's communication is when it's clearly communicated, when it clearly communicates the intent to enter into a binding contract with the offeree. So that's the communication from the offeror. So the communication of intent to be bound from the offeror must be present. The offeree has to receive and understand the offeror's intent to be legally bound by the contract. So why is intent important? Intent is critical to the legal definitions, and it determines the nature of agreements and obligations. The objective intent evaluation is where the court assesses objective intent based on case law and actions, focusing on what a reasonable person would perceive. The reasonable person test is that intent is determined by a reasonable person's interpretation of the offeror's actions, ensuring fairness and objectivity. In contract negotiations, there has to be precision, definiteness, and specificity in making the offer. So offers must be exact and accurate. This helps to avoid misunderstandings or disputes. The definiteness, it means that they should be clear and unambiguous and have well-defined terms. Specificity in offers means that the offer needs to detail and specify information to ensure all parties understand their obligations. Now we're going to talk about how to apply the reasonable person standard. Applying the reasonable person standard, there is an objective test involved. The reasonable person standard, it's an objective test to evaluate behavior based on ordinary meanings. An ordinary meaning, that means the words, conditions, and time periods are interpreted by their ordinary, everyday meaning, not through technical terminology. The inducement of belief in the offeree is another important principle in terms of the offer to a contract. The ordinary meaning of the terms of the contract has to be taken into consideration. The terms must be understood as an ordinary person would interpret them in everyday language. Remember, we're covering the reasonable person standard. So the ordinary person would interpret them in everyday language. Their inducement of belief. The offerer must communicate a belief that reasonably induces the offeree to believe an offer exists. And there has to be serious intent. Evaluate when an offer is made, evaluate if the offer has an objective and genuine intent, the offeror has an objective and genuine intent to proceed with an agreement. And sometimes we are testing the waters, and that means to determine whether the offeror is engaging in preliminary negotiations without a firm commitment. Definiteness and certainty of the offer terms is essential. It's important, the specification of material terms such as parties, price, subject matter, time. Everything must be definite and certain. This is important for the clarity piece. The offer must be clear and unambiguous for the offeree to understand what is being accepted. And when it's specific, it increases the validity of the offer. So the more specific the terms are, the greater the increase of the likelihood that the offer legally exists and can be accepted. Now, specification of the terms such as parties, price, subject matter, and time. We'll look at that next. The parties need to be clearly identified. So the offer must clearly identify all persons intending to be bound by the contract. This avoids ambiguity. If the offer must state a specific price that cannot be negotiated later to ensure clarity and enforceability. And the subject matter must be clearly identifiable and not open to question for contract validity. And the offer must specify a reasonable time frame or include a time of the essence clause for contract performance. So to be safe, we need these clear specifications of material terms. Next, we'll cover output and requirements contracts. So what is the nature of this type of contract? This is when a seller agrees to sell their entire production exclusively to a designated buyer under the output contract. Both parties depend on each other to act honestly and uphold the terms of the contract. Requirements contracts and buyer obligations we cover next. The requirements contracts emphasize the buyer's obligation to purchase exclusively from the seller, and the buyer agrees to buy all necessary goods exclusively from a specific seller under the contract. There's also a necessity for communication and knowledge of the offer. The necessity of a communication for a valid offer has a communication requirement. An offer must be communicated to the offeree to be legally valid and effective. The offeree must be aware of the offer to have the power to accept it and create a contract. So it's invalid without this. What about advertisement? Advertisements are an invitation to negotiate. Advertisements are usually invitations to negotiate rather than definite offers in legal terms. Advertisements also serve as preliminary negotiations, encouraging potential buyers to make offers. And advertisements typically lack specificity and definiteness of terms, which is required to be considered a legal offer.
I hope you got some good information from this video lecture. Don't forget that I have a Teachable school account. Here is the address for that, mayananda-s-school.teachable.com. The name of my school is Mayananda. And also there's a coupon here for you to save some money. And finally, good luck on the exam. And don't forget to like, share, and subscribe.